Okay, well, we're now going to get started. It is just a few minutes after 6:30, and we're going to keep the doors open for all of our attendees to join us. Like I said, we're expecting a full house of approximately 100 people this evening. Allow me to introduce myself. My name is Patty Smolin. I am the business librarian at the Schaumburg District Library. I am the coordinator of tonight's program, and I am so glad to welcome back Jacob Ehrensaft, who has returned to our library and to a number of other public libraries to bring the topic, very necessary topic, about wills and trusts and estate planning. So many libraries do work in sync with each other. Jacob was introduced to me and referred to me over 8 years ago by the Niles Public Library, and we're very pleased that we can still welcome him back every year at least once. For tonight, we are doing this on Zoom only because even though we've had Jacob here in person before, when we planned this initially, we just weren't sure how things were going with COVID and with the numbers. So to be safe and to make sure that we could accommodate all attendees, we did it this way, which I think worked out pretty well because we do have a full capacity. But we'll see how we are in the rest of the year and if we can do it differently and welcome them back in person. I do want to make mention that the library is open. We are open until 9 o'clock at night during the week and until 5 on Saturday and Sunday. I did provide my email address in the chat to those that have questions that I can help with as a reference librarian. Please keep in mind that I do not provide any guidance when it comes to legal matters. That is a professional and expert area of which I am not studied, well-versed, or proficient in the slightest. I can guide you to credible sources, but I cannot carry out those requests that you may have any more than I could in the medical or financial arena. But the library is open to answer some of your beginning questions and point you in the directions of those that can. The good news is tonight's program will be recorded. It's not going live on our YouTube channel, but it will be recorded and it will be up on our YouTube channel for another month. So if you want to take a look at Jacob's slides again or refer a friend, I will put the link in where you will be able to find his presentation as of this time tomorrow. I see that we have something in the Q&A already. I'm going to address that very quickly. Okay, so we are already starting to get questions for Jacob, and his session hasn't even officially started yet. So let me just lay out a little bit of the foundation work here. He is going to welcome questions, and you can submit those either through chat or through the Q&A icon, either one. But he's going to save those questions until the end because it's just possible that his content will address those questions. So any questions that you have, you can either hold on to them and enter them at the end, or if you feel like you want to release them into the chat, please do so. And again, I will monitor the questions and I will field them to Jacob as he asks me to. With that in mind, I want to say thank you so much to Jacob for coming back again this summer or this spring. We're really happy to have you here, Jacob.
And thank you for welcoming me back, Patty. It's been a pleasure speaking with you for all these years and hopefully for many years to come.
And I thank everyone for making the time to join us tonight. We do have 63 attendees where, like I said, we may have others, but I always believe we should put up as many seats at the table as we possibly can. And with that, Jacob, I'm going to turn this over to you. I'm going to turn my monitor off and I'm going to mute myself. And please just pull me back if there's any tech issues that come up or if you want to take a pause and address questions at any point.
Okay, thank you, Patty. Okay, well, welcome everyone to the Wills and Trusts program. Before we actually begin the program, what else can you expect from a lawyer but a little bit of a disclaimer? Today's program is for informational and educational purposes only. Nothing in this program is or should be considered legal advice. If you do actually need legal advice, you should speak to an attorney in his or her office. Now, the title of this program is Wills, Trusts, and Estate Planning Basics. However, before I can really address that, I really want to go into what most people are generally coming to me to avoid. And this is what we refer to as probate, specifically probate for decedent's estate or an estate being opened because somebody has died. Now, probate is the court process for distributing a deceased person's estate. If you die, at least in the state of Illinois, if you have $100,000 or more without a listed beneficiary who survives you, or you have any real estate in your own name that's not in a trust, that doesn't have some other type of co-ownership or listed beneficiary, probate is going to be required. It's not necessarily that there's litigation, but the way it works is the court wants to ensure that if you had $100,000 plus or you had any real estate, that the appropriate parties are noticed or receive notice. And you can imagine if somebody died, their heirs at law need to be notified. Whoever your heir is depends on the probate estate and I should say the Illinois Probate Act. And also, if you have any creditors, just because you've died doesn't mean your creditors go away. Creditors still need to be paid. Now, probate's not the end of the world. Some people said, well, I heard there's probate and it means it takes all my money. That's usually not the case. But most people would generally want to avoid it because of the time it takes and the expense. Probate takes a minimum of 6 months from the time the estate is opened until it can be closed, because creditors have a 6-month window in which to submit a claim, as well as all potentially heirs of the estate. Also, the expense. I'd say going through probate, usually the cost is about anywhere from 2.5, 3 times to 5 times the size or the cost it would be if you initially did estate planning to try to avoid it from the beginning. But some people say, well, I don't really care what happens to my money if I, die, or if it goes through probate and my beneficiaries have to pay more and it takes longer. Oh, well, as long as you understand that it's completely fine to go through probate. Probate has been around for a long time. It will be around for a long time. Almost all probate estates could be avoided. There are some that can't. If you died because of a wrongful death case and somebody needs to bring a wrongful death action, probate may be required for that. And this is specifically probate for decedent's estates. But I usually tell people if there is a probate estate, you want to try to do it and address it as quickly as possible. Before COVID, at least with Cook County, I should say, my clients would come in and they'd ask me, well, how long will it take me to open up a probate estate? I'd say after everyone has notified and I get some court forms back from the heirs at law or the beneficiaries listed under a will, it'll probably take me about 2 or 3 weeks to open up the estate. And then you've got a 6 months procedure. And after that, at earliest, maybe we could close it. After COVID, it's been a little bit of a different story. I usually have to tell my clients, well, after I get my documents back from all the potential beneficiaries or heirs at law, it's going to take at least 3 months for me to open up a probate estate. Even if we open the probate estate in 3 months, in order for me to get the court documents that the executor or administrator is going to need to access any of the money, file the tax returns, etc., it's probably going to be another month if we're lucky. And if the judge has any requirements or finds that they need any additional documentation, add another 2 months to that. So where avoiding probate, I think, was fairly important beforehand, I think it's even more important now to at least consider avoiding probate. Or if you're already in the midst of that, if somebody close to you has passed away, I'd encourage you to start more quickly than later, because the process is going to take a while. And usually I tell people, probate, as I said before, it's a 6-month period from the time the estate is open till it can be closed. Rarely are estates open and closed that quickly. Most probate estates probably take about a year to a year and a half. Oftentimes, some things need to be addressed, and this is assuming no litigation, no hard to sell assets, no businesses, but oftentimes somebody might need to try to locate the assets, perhaps clean out the house, if there is one, or any real estate, and then to sell it, and then to make sure the taxes are paid, etc. However, depending on who the executor administrator is, you have to watch out. I have a probate estate that's been open for 5 years, not because it's very difficult, just because my executor has had some health issues, and my executor also does not move very quickly, as we'll see later when we talk about wills and trust. Choose accordingly. You want to make sure you have somebody who acts quickly. Whenever you're doing anything with estate planning or probate, you want to act quickly, or most areas of law too. Lately, I've also been involved with a colleague who does a number of personal injury lawsuits, but when somebody has died or become disabled because of that, usually a probate estate has to be opened. If you do have a personal injury, wrongful death, medical malpractice case, something of that nature, I always encourage people, address it as soon as you possibly can, because there are time limits on that. And if you don't submit a claim, it will be forever barred. Also, the longer you wait, the worse your case gets, at least for personal injury and wrongful death, because evidence needs to be preserved. And it doesn't look quite as serious to everyone and the court when you've waited 6 months or a year to make a claim. So, but that's it mostly for probate. I could speak longer on that, but usually I tell people, yes, ideally you at least want to find out what your options are as far as avoiding probate. If you're not going to go through the appropriate legal processes, we'll see later with perhaps a will or a will and a trust, perhaps avoiding probate is not the best method. A lot of people try another other routes that they've heard from friends, family, or the internet, which, as we'll explain later, does not always work as people have intended. Now, some people will say, well, I really don't care about what happens to my money when I die. Of course, if that's the case, I don't know why you're attending a program on wills and trusts. But at the same point, there is something you should be much more concerned with. And this is what we refer to as guardianship, or specifically guardianship for disabled adults. Now, this is the court process for appointing an individual known as the guardian to make decisions, which could be healthcare decisions, financial decisions, or both on behalf of somebody else. And if you don't get anything else from today's program, this is really something you want to avoid at all costs. It's very easy to avoid it as long as you're 18 or older and capable of making your decisions, as you'll see later. But most people don't like to think about death, let alone becoming disabled. And if they have thought about becoming disabled, maybe you think that, oh, if I'm married, my husband or my wife could make decisions for me. Maybe my adult child could make decisions for me. Or maybe my adult child who lives with me, maybe is going to school, college, is working and is younger. Maybe I could make decisions for him or her, right? Well, unfortunately, that's not the case. Every year I get phone calls from people who are distressed saying that, well, my husband, my wife, my child, my parent can't make decisions. I can't get his or her medical records. I can't reach his or her money to pay the bills. Financial institutions or the healthcare institutions are asking for powers of attorney. Can't we sign them? Well, as we'll see later on, no, you have to do that while you still have capacity. If you don't have capacity and you haven't planned ahead, guardianship, at least for a disabled adult, is really going to be your only option. And unlike probate, which I said is usually a minimum of 6 months, more likely in most cases a year to a year and a half, guardianship will last from the time somebody becomes permanently disabled until their death. There are some extremely rare cases where somebody can lose their capacity and regain their capacity, but I'd say that's probably less than 0.5%. I've had one case and I've been practicing for about 18 years now. And most people never get a case. That's usually when somebody is off their medication, maybe goes back on, and they have to do some planning to make sure if they ever go off it again, that somebody can make decisions for them. But guardianship, as I said, lasts indefinitely. So if somebody is disabled for 5, 10, 15, 20, or 30 years, that's 5, 10, 15, 20, or 30 years of ongoing court costs, attorney fees, accountings, etc. And guardianship is a much more intrusive process than probate for decedents' estates. It involves the court requiring a physician's note. So for the person who's disabled, you have to get that person to the doctor, and the doctor has to state that this person is incapable of making his or her own financial decisions, healthcare decisions, or both, and to what degree. Can they not make any decisions? Can they only make some decisions, etc.? The court also has a sheriff come out and serve that person to state that you've got a court date on such and such a date. A person is claiming that you can, that you're incapable of making your decisions. And if that's going to be the case, you've got the right to appear on the state and contest it if you so wish to. The court also has their own court-appointed lawyer. It does not represent the person who's trying to be appointed as the guardian. It does not represent the person who is allegedly disabled. It represents the eyes and ears of the court to see from a legal perspective if this person should or should not have a guardian appointed. The court really doesn't want to take away somebody's decision to make healthcare or financial decisions for themselves, unless they really can't. And in most cases, you know, if I'm doing it, usually the doctor is going to say they can't make any decisions for themselves. One somewhat comical decision was I had one person who was disabled and I was representing the guardian. And fortunately, the guy had a good disposition and obviously he couldn't make his decisions. But the court-appointed attorney who's called the guardian ad litem went to visit this allegedly disabled individual, said, hey, somebody's applying to be your guardian. He was a little hard of hearing. He said, I don't need a gardener anymore. I already have somebody who cuts my lawn. Merry Christmas. And it was in the middle of July. So the court-appointed attorney said, this guy might benefit from a hearing aid, but as I was coming to him in a nursing home in a suit with a briefcase, I don't think he had too much capacity if he really thought I was trying to be his gardener. So, but that's guardianship in a little bit of a nutshell. And I will point out, you know, this is not a fun process for the person who's allegedly disabled. If he or she knows what's going on, being visited by a sheriff, being visited by a court-appointed attorney, and then potentially needing to appear in court. It's not a lot of fun for the friends or family. It can be very stressful, especially if there are, let's say, numerous children or aunts, uncles, brothers, sisters, whatever the case may be, because they may disagree where this person should live. Should they be living at home with a caregiver, in a nursing home, assisted living, etc.? And more so, how should the money be spent? Who should be managing it, etc.? Also, for anything out of the norm, if you want to sell the house, if there are going to be some expenses that are not day-to-day expenses, for all of those decisions, even if everyone agrees, you're going to have to get court approval, which means more court costs and attorney fees. So not that great for the family and friends, not that great for the allegedly disabled person. The only person it's really good for, somebody like me standing in front of you. The attorney is getting paid hourly for however long this procedure is going to take. So I like to call this program Wills, Trusts, and Estate Planning Basics. If I just call it estate planning, a lot of people find that a little too intimidating. But really in estate, what that means for today's program, it's just everything that you own. If you've got $1, you have an estate. Even if you don't, maybe you just need somebody to make healthcare decisions for you. So really keep that in mind. I've represented people who have had $2,000 and have been on Medicaid. I've represented people $10, $20 million, etc. It just really depends. But for everyone, there's an appropriate plan, no matter, you know, what the size of your estate. So don't let that stop you from doing estate planning, no matter how easy or how complicated you think it may be. Now, estate planning is not just about who gets your assets when you die. Of course, that's a large component of it, but estate planning is really a process where individuals can determine who will act on their behalf if they become disabled. If you have minor children, who will care for them? Where are they going to live? Where are they going to go to school? How is their money going to be invested? When will the money be dispersed to them? And also, who will receive your property when you die? Are there any people who would normally under the law not receive it, like perhaps a spouse or a child or a parent, brother, sister, etc., family member? Also, for the people who are receiving your property, will they receive everything all at once? Will they receive it in increments over time, perhaps some at one age, some at another age, etc.? Will they just receive a stream of income? Or do you want to make sure that perhaps somebody doesn't receive the money and that money just goes for his or her expenses? As we'll see later, what if somebody has a substance abuse problem, drugs, alcohol, or gambling or something of that nature? You want to make sure sometimes that you have to protect that recipient from him or herself if they were to receive money from your estate. So most people will generally come to me and state, you know, I have a really, really simple plan. No one ever says, Jacob, my estate planning is going to be really complicated and really expensive. But I always will tell people, you know, let's find out what you have. Let's find out what you want to do. Some small estates can be very, very complicated, and some large estates can be very easy. It just depends. It's not just about how much money you have, but it's also about who your beneficiaries may be, and obviously what your wishes are within reason. I can make plans that are very, very complicated and sometimes address some very difficult issues. And I do some that are very straightforward. It just, depends. I'm always for the most straightforward way possible, but, sometimes more complexity is obviously needed. So now the basic estate planning documents are wills, trusts, powers of attorney for healthcare, powers of attorney for property, and living wills. I'll speak about what I think is easiest and move my way down to what I think is most complicated. Now, living will has nothing to deal with who will get your property when you die. A living will is a document where somebody refuses medical treatment if he or she is suffering from a terminal illness. And this document, usually, for example, if your doctor has this ahead of time and you already have some underlying terminal condition, the doctor is not supposed to, or medical institution is not supposed to give you artificial life-sustaining equipment such as a respirator, artificial feeding, hydration, etc. But you have to have a terminal illness. This is not quite the same as a do not resuscitate order. A DNR, or in Illinois was referred to as a post. Most attorneys do not prepare these. These have to be signed by your doctor. This says, don't try to save me no matter what. My clients that have them, I say I'd like one for my file, but most lawyers don't prepare it because it does have to be signed by a doctor. And this is usually for people who are perhaps fairly sick. Maybe they're in hospice, or maybe they're otherwise healthy, but they knew they just wouldn't want to continue because of their age or whatever circumstances they may be in. So that's all I'll speak on for a living will, but I'll give one good example. So a number of years ago, everyone may remember a young lady named Terry Schiavo. She was in her late 30s, early 40s, probably never thought about dying, let alone becoming disabled. But for close to a decade, she was on artificial life-sustaining equipment and she was in a coma. And her husband was arguing through the courts that she should be taken off life support, while her parents were arguing she should be kept on life support. Now, what she wanted, we will still really never know. Even if she put this in writing somewhere, if she didn't reduce it to the correct legal format, it's going to be inconsequential. So realistically, you want to make sure that your wishes are abided by. And I realize these are not always the easiest decisions, but much rather you make them now while you're still coherent, as opposed to waiting in the future where you may or may not be as coherent. Usually most people don't get more capacity as they get older. Usually it declines no matter, if you're maybe if you're not 20 and 30, but if you're going from 80 to 90 to 100, obviously choose accordingly. So next form we'll speak about, and this is different from the living will, is the power of attorney for healthcare. It's probably what I consider the most important form, or at least one of the most important forms that I'll speak about today. And this is a form where you can appoint somebody to make medical decisions on your behalf and prevents guardianship, at least with respect to healthcare decisions. Now, the power of attorney for healthcare, you can appoint one person at a time to make as many one person at a time, but as many people in succession to make decisions for you if you could make your own healthcare decisions. So I could say, first choice is my wife to make decisions for me. My second choice is my daughter. My third choice is my father. Fourth choice is my friend, whoever I think is best. Doesn't have to be anyone related to me. It could be, but really choose accordingly. A lot of people, I think, arbitrarily say, well, I'll choose my spouse because I'm married to him or her, or I'll choose my oldest child. You need to choose who is really right for you. If your spouse would have a hard time disconnecting you from life support, or is not great about making decisions, or perhaps, you're both older and it's very difficult for you to make decisions, or it's very emotional, maybe that's not the right person for the job. You really need to choose who is best for you. Don't worry about hurting one of your children's feelings. You need to really choose the right person to make decisions for you. So I do urge people to think about that. And as I said, only one person at a time. Illinois courts want to avoid the process where you name two people and one person says we should do X and the other person says we do Y, and you go into court to fight. So one person can make the decision. Of course, he or she can speak with your doctor or your medical professionals and speak with the other family members or friends. but that will be the only person who makes the ultimate decision for you, assuming he or she is not doing anything egregious or is not obviously neglecting his or her duties. Then you can get that person potentially removed. Now, the next form is called the power of attorney for property. Don't assume this means power of attorney for real estate. It's what Illinois calls the power of attorney for finances, or what you might see in AARP or something more general called a durable power of attorney. All durable means that it survives your incapacity. There are other types of powers of attorney, such as maybe when you want to sell your house, it will say it's only for the purpose of selling your house. It terminates maybe in 30 days. This is not meant to usually be done if you can't make your financial decisions. It's just allowing your attorney or perhaps a spouse or somebody else to sign documents for you if you don't want to show up to the real estate closing. But the power of attorney for property, you can appoint somebody to make financial decisions for you. It's one person at a time, but as many people in succession as you'd like. When you're choosing the person for this job, make sure whoever you're appointing is somebody who is responsible, somebody who acts quickly, and also somebody who is honest and good with money. Also, one person at a time, as many people in succession as you would like. But I can't stress how important it is to really choose the right person. I've had a number of estates, sometimes where it's a power of attorney, sometimes an executor or a trustee. And if that person is acting very slowly, your estate may not go as planned. If that person is bad with money, has healthcare issues, financial woes of his or her own, things may not go as planned. Every now and then somebody, quote unquote, borrows some money from the estate. Legally, they cannot do it, but it does happen. So choose the right person for the job. And this prevents guardianship for financial decisions. Also with these forms, consider the age of the person. A lot of times people will choose their children, but people are living a lot longer than we had anticipated. My grandmother passed away at 105 years old. Probably didn't consider that my dad, who was the executor, would be in his mid-70s when she passed away. Luckily, obviously, her grandson was an estate planning attorney, but honestly, fairly difficult. So I usually tell my clients, you may want to consider even listing a grandchild or perhaps a third party in there, just in case, because your kids may be 70, 80, 90 years old, or your friends or brother or sister. So you may want to consider somebody in a younger generation. And let's put this onto a good example. So people always ask me, Jacob, at what point in my life should I do powers of attorney, a will, a trust, etc.? And anyone who's seen my program before knows the answer. I usually tell people you should start doing your estate planning after you're 18, assuming you can make your own decisions, and before you die or become disabled. If you can let me know exactly when you're planning on dying or becoming disabled, by all means, we'll come in a few days beforehand and get everything signed. But realistically, don't wait until it's too late. That really should be the overlying theme of today's program. I realize it's not a lot of fun to do estate planning and do it correctly, but at the same point, it's a lot better for you. It will be a lot better for your friends and family, as opposed to there being an emergency. And when there is an emergency and people are not sure about somebody's capacity, they're very sick, this is the case where a lot of these documents can be defeated because it's questionable about the decision-making capacity of, somebody in that sort of situation. And it can be very stressful for them and their family. And as the attorney, if I have to drop all of my work and see somebody, within 24 hours, most attorneys are going to charge a premium to, let everything else go and try to address that one major issue. And let me give one good example. So a number of years ago, I had a few clients who came to me, not a difficult estate, just wills and powers of attorney, not a ton of money. But I had all of the paperwork completed, and my client asked me, he called me and he said, well, we'd like to sign our documents. And I said, great, let's try to sign them in the next week or two. And he said, well, we're probably gonna wait maybe about 5 or 6 weeks. And I said, why do you want to wait that long? You've already paid me, I've got your documents in place. And he said, well, next week or two, my wife's going in for some minor surgery. I said, minor surgery? He said, don't worry, it's just outpatient procedure, nothing to be concerned with whatsoever. I said, still strongly recommend that you get this done and you get everything in place. And he said, thanks for your recommendation, but it'll just be more convenient for us in about a month, month and a half. I said, all right, nothing I can do. About a month, month and a half goes by, I get a call from my client. Not the call that I wanted. He said, well, you know, my wife was doing fine after her surgery, but there were some complications, had to go back to the hospital, had to have a few more procedures, and she's in a coma. The doctors are asking for her power of attorney for healthcare. And by the way, all of the money that she has is in an IRA. Even though she has beneficiaries on that IRA, that has nothing to do with who can make decisions regarding those funds while she's still living. So you've already got the forms done for her. Can't you just give me those forms? Can't we just give them to her hospital? And can't I use her power of attorney for property to express, you know, that I can make her financial decisions and pay her bills? Of course not. The forms are not signed. They haven't been witnessed. They haven't been notarized. So even though we had everything ready to go, had to go into court, had to get the court to appoint the husband as the guardian. And then later on, client died. In her IRA, she had about $150,000. Fortunately, she had named beneficiaries, but her named beneficiaries were her parents who are now deceased, had to go into court, had to have probate for decedent's estate. Took about 8 or 9 months to get that wrapped up. And then at the end of the day, everything was done. Just cost a lot more and took a lot more time than would have been necessary if they would have actually planned appropriately. It's not enough to just start the estate planning process. Some of my clients consistently delay, but it's at their own peril. There's nothing I can do rather except for call them and bother them and tell them you really need to get these documents signed. So without further ado, I'll go to the next slide, and people will tell me, well, Jacob, you know, I've already done my will, my trust, my powers of attorney. But I always tell people, well, you should always make sure your documents are up to date. If anything has changed in your life, such as you've come into a lot more money, you have a lot less money, perhaps you did planning when your children were much younger, now they're older, maybe you've had another child, maybe one of your children is disabled, maybe you want to change your beneficiaries. You should really do that and do that correctly. Just scratching out somebody's name and initialing it has no legal standing whatsoever. You have to do it and do it properly. And it holds a lot more weight if an attorney has actually done it, as opposed to if you try to do it yourself or with somebody who is not an attorney. And some people will say, well, nothing has really changed with me. Do I still really need to think about updating my documents? Well, yes, because even if nothing has changed with you, something may have changed with the law. I will guarantee you, if you did your estate planning prior to July 1st of 2011, at very least your powers of attorney do not comply with the current law. There were a number of changes, and I'll go through some of the major reasons for these changes. And it's not to say that your old powers of attorney are completely useless. If somebody is already disabled, they obviously can't change them. But if you're able to make your changes, I'd strongly advise that you update your forms to comply with the current law. The first one is for the power of attorney for property. In this form, it says, I revoke all prior powers of attorney. Well, what does this mean? Well, you'd assume if you did a power of attorney for property in 1990, and you did another one in 2000, the one in 2000 is the only one that's good, right? Well, perhaps not. I could be very easily argue that they're both still good. The new one, at least if you have the appropriate form drafted after July 1st of 2011, it revokes all prior powers of attorney. It says this is the one that I've most recently signed and all the other ones are not good anymore. There's a cover page that's supposed to tell you a little bit about what you're signing. It says, you know, you're appointing somebody known as your agent to make financial decisions on your behalf. You don't have to sign this form, but if you don't sign it, it's not good. This power of attorney may take place before and or after you are disabled, depending on the language. And if you have any questions regarding this form, you should ask an attorney to explain it to you. Now, I will say the cover page is a little bit more convoluted and a little bit more legalese than it should be, but I guess it's better than not having anything. Power of attorney for healthcare also had some very important changes. Compliance with HIPAA, the Healthcare Insurance Portability and Accountability Act of 1996. And what's that? Well, you might remember long time ago when you used to go to your doctor, they used to give you a sheet of paper and it would usually say, under federal law, we cannot disclose your medical information to anyone without your prior written consent, et cetera, et cetera. Nowadays, you tap a little screen. It says, I've read this, I comply with this, et cetera. But what does that mean? Well, your old power of attorney for healthcare might not be useless. Somebody might be able to make healthcare decisions for you, but under federal law, your hospital or doctor cannot release any of your medical information to that person who's supposed to be making your medical decisions. A little bit problematic to say the least. The new power of attorney for healthcare does comply with that. And there are other forms. I know I've discussed it with a few people over the last few days. There are some forms that are not necessarily bad. Something called like the 5 wishes goes into a lot more depth. Most attorneys are not huge on it. That does not comply with HIPAA. It is not a substitute for the power of attorney for healthcare. Some clients might want an addition to it, but I'd use caution and I talk to people, individual to individual to see if that's the right choice for them. But the power of attorney for healthcare is very important and very important that you are using the right form. And some people will say, well, I did my powers of attorney and my estate planning after July 1st of 2011. I'm fine, right? Well, maybe not. At least for the power of attorney for healthcare, the state of Illinois updated it yet again, January 1st of 2015. And the purpose for this was I and a lot of other attorneys who also do estate planning and probate work thought, they needed something that was a little easier to read. A lot of people are getting this form. They're in a hospital, a nursing home, hospice. This is the first time they're reading it. It doesn't need to be very convoluted and then legalese. And the new form is meant to be more efficient and simple and ask a number of good questions, such as what do I want my agent to know? What decisions can my agent make? Who should I choose as my agent? What do I do with this form? And what happens if my agent does not act? Now, some people also tell me, well, I did mine after January 1st of 2015. Well, this is the point where I should point out not all attorneys are created equally. It's not to say that I'm the only good estate planning attorney out there. There are others as well. But if you just use somebody because they did your divorce or your personal injury work or, excuse me, or your real estate closing, that may not be the right person for the job. Because just if you sign these forms after January 1st of 2015, you need to watch out for a few things. Because a number of years ago, I shared space with or I didn't share space, I was in the same building as another attorney who I knew, brilliant guy, but he did general practice, a little bit of everything. And one day I asked him to come and ask him if he would be a witness for a will signing for me. And he said, sure. A few hours later from his office, I got a call. And his secretary said, Jacob, the attorney I work for said he hasn't seen your power of attorney for healthcare or property forms. Would you mind giving us a copy? And I said, sure, as another attorney I know and like, I'd be happy to give you forms. But that meant for the last several years, all of his estate planning clients, he was preparing forms for them that didn't comply with the current law. I wish I could say this was a minority of the cases. People come to me numerous times and they have powers of attorney that were drafted a few months ago that just don't comply with the current law. That attorney did not, do his or her due diligence to make sure that their, that our documents were up to date. Estate planning is an area that you should really concentrate in, even though it might be a very simple estate. If you don't do your job and do it correctly, things can go very wrong. So that's what I'll say on that for the moment. Now, we can get to simple wills. Everyone can take a sigh of relief. Most of you have probably seen one of these, but you may not really understand the benefits and shortcomings of a simple will. Simple will give assets to beneficiaries outright. So a simple will for me might say, if I die, everything goes to my wife, or if my wife doesn't outlive me, everything goes to my daughter. Most simple wills generally go through probate. And if your estate goes through probate, information is available to the public. And let me explain why this is important. people ask me, well, I thought if I had a will, my estate doesn't go through probate. Why do I even need to do one? I think it's completely useless then if I do it. Well, not all estates with only a will go through probate. It depends. If you are married and all of your assets are held jointly or list your spouse as the beneficiary, assuming your spouse outlives you, there's generally not going to be probate when the first spouse dies. But when the second spouse dies, if there's only a will, assuming the assets equal or exceed $100,000 or containing a real estate that's not in a trust, that doesn't list the beneficiary who survives you, probate is going to be required. But there are some major benefits to a will. A, you can name your executor. The executor is the person that when you die will be responsible for contacting an attorney to take the estate through probate. They'll be responsible for gathering your assets, for paying off any rightful creditors, and for distributing the money to the rightful beneficiaries. Also, in a simple will, you can state who your beneficiaries are. A lot of people would assume, well, if I die and I'm married, everything goes to my spouse, right? Not necessarily the case. Some people find this out the bad way, and actually one of my colleagues called me and was very nervous, and I told him, oh, we're going to have to look at something to make sure this isn't the case, and let me explain. So the way the Illinois Probate Act works is if you die and you're only married and you have no children, everything goes to your spouse, assuming you don't have named beneficiaries naming somebody else or a will or trust naming somebody else. If you only have children, everything goes equally to your children. But if you're married and you have children, half goes to your spouse. Well, actually, your spouse gets $20,000 off the top, and then the rest is divvied up equally between your spouse and your children. So if you died and you had a house that was worth $220,000, your spouse gets the first $20,000 and $100,000 worth of that house. Your kids, how many ever of them, if there's one or there's 10, they get the $100,000 divided between them. And this is what happened for somebody. It was a very bad case. It unfortunately happens more than you'd like to think. No one ever talks about it because it's a bad situation. But what happened is this poor lady, her husband died. His name was the only name that was on the deed. She had 2 kids. One kid said, yes, I'll sign over the deed to you, Mom. The other child realized that if he didn't get his inheritance now, he was never going to get it. He didn't want a fourth of the house. He just said, no, I'd like my 1/4 interest in the estate, forced his mother to sell the house, got the proceeds, and then the brother and the mother never spoke to him again. Not a great idea, but even if you're married, even if you think your estate is very easy, a simple will is at the least the bare necessity. Usually not as good as a trust for most people, but much better than not having anything at all. Also, I'd say simple wills can be very important even for people who do not have a lot of assets now, because a will not only deal with the assets that you have now, it may deal with the assets you may have in the future. And let me give you 2 examples, one happier, one not quite as happy. One of my clients did a will, only had about $50,000. A few months later, called me. He said, I won the lottery. I'm now worth $1,050,000. I said, okay, at that point, we should probably do a trust. A will still do it, but a trust would be much better in your situation. But another case scenario would be when somebody doesn't have a lot of money, but they may receive money. And let me give one example, maybe not quite as cheery, but rather be prepared for it. So one lady came to me, didn't really have a lot of money. She was on Medicaid. She only had $2,000 to her name. She only came to me because she wanted a power of attorney for healthcare. And I said, well, just in case, I'm not going to charge you anything extra if I just do the power of attorney for healthcare, as if I do a power of attorney for healthcare and a power of attorney for property. And she said, okay, fine. I don't see why it might be that important. But I said, you never know. 2 months later, I got a frantic call from her daughter. She had been in a terrible bus accident. What happened was there was an accident and she became a quadriplegic. In order for her daughter to proceed with a claim, she was able to use the power of attorney for property to proceed against the owner of the bus and to sue them. But I said, well, just in case she dies, we might want to have a will, at least name the executor, and make sure that no one else comes after the money. Make it fairly clear that the daughter was going to be the recipient. There are some other reasons I don't want to get into, but those were some major reasons. And we had the will signed, and it made it a much easier process when the mother died, because her estate that was originally a couple of $1,000s wound up being worth over $1.5 million for that. So you really have to consider that. I sometimes get calls from people and they say, well, our father died and, we might want to do a personal injury, claim, but I sometimes have to tell them, well, that might be the case, but even if you spent all that time with your mother or your father and you haven't seen your brother in 20 years, he's still going to be entitled to 1/2 of the money because your mom or dad didn't do a will. So always think about that. I realize a lot of people don't think like this, but an estate planning attorney usually does. A lot of clients, I usually tell them, they think about estate planning like a checkerboard. It's one step ahead. For estate planning attorneys, we usually try to think several steps ahead and see what may happen. But as I said, a simple will is usually the minimum. Most people would benefit from a trust, but not everyone. It's a case-to-case basis. Some people I watch on TV and they say everyone needs a living revocable trust. I think everyone needs to be examined. They need to tell the attorney what they want, what their situation is, and have the attorney make a recommendation and then decide from there, just not arbitrarily do it because somebody says everyone needs this or everyone needs that. The only thing I would say everyone definitely needs if they're 18 or older and can make their own decisions is a power of attorney for healthcare. Everything else, it depends. Now, the other type of will that's the most common is what is referred to as a pour over will. This is like a pitcher pouring over into a glass. Don't be too concerned with this. It's very similar to a simple will with one or two major differences. If you have a simple will, that's your main document. As I said, it might state, for example, for me, if I die, everything goes to my wife, or if not, it goes equally to my children. However, a pour over will usually says if I die, all of my personal property, all of my car, jewelry, furniture, clothing, books, etc., go to my wife, or if not, it goes to my children. But anything else I might have, whether it be real estate, whether it be a bank account, etc., goes to my trust. And my trust says everything goes to my wife, or if not, equally to my children. So if you have a simple will, that is your main document, at least for your assets when you die. If you have a trust, your will is a supporting document that works in unison with your trust. That's all I'll really state on that. If you have any questions later, I will answer them. But I promise we'll have a little bit more fun, and I'll give a few more examples in a few minutes. So the last and probably most complex thing I'll speak about today is the living revocable trust. It's called a living trust because it's supposed to be created during somebody's lifetime, and you're supposed to put the vast majority of your assets in it with certain exceptions while you're still alive. And it's called a revocable trust because you could still change it. It's not written in stone. As long as you're capable of changing it, you might be able to change that in the future, assuming you're still capable of doing that. Let's go through some of the benefits. These are not all of them, but these are the major ones for usually living revocable trust for most people that don't have taxable estates. If you have taxable estates or other situations, there are other benefits too. So living revocable trust can be used to avoid probate, but only if they are used properly. What do I mean by that? Well, a living revocable trust, I tell people, think of this, and it also can be used for protection against guardianship, but only for assets that are in the trust when you die or become disabled. So I tell people, think of a living revocable trust a little bit like a corporation, because a corporation can own things, real estate, bank accounts, furniture, etc. And the corporation is generally controlled by the president. But if the president dies, becomes disabled, or just no longer wants to do it, the corporation doesn't usually cease to exist. There's usually a vice president that steps into his or her shoes and continues to run the corporation. At least for a trust, it's the same. You control the trust while you're still alive. You can still take the money out. You can still spend it, save it, do whatever you'd like. But if you die or become disabled, or you just no longer want the responsibility, somebody else takes over, but the trust is still the true owner. And that's why probate is avoided and guardianship can be avoided. Now, keeping information private, we'll go back to something I alluded to but skipped over previously, which is, avoiding probate. Well, if your estate winds up going through probate, the information is available to the public. Anyone can find out exactly how much you had when you died and who the beneficiaries are. And some people will say, well, what do I care? I'll be dead. What do I care about that? Well, you really should care, and let me explain why. So a number of years ago, I got a call from somebody who was extremely frantic. There was a problem with their mother. Their father had died numerous years ago. He had a lot of assets. They wound up going through a will and going through probate, but they all went to the wife. And after a number of years, she was ready to move on with her life, and she met a very nice, sophisticated, handsome gentleman. And after they had been dating for about 6 months, he gave her a very nice, sophisticated business proposition. One that didn't just require some of her assets, one that required all of them. And her kid said, Mom, what are you doing? What do you know about this guy? Don't trust him, et cetera, et cetera, et cetera. And she probably said what we'd say to most of our kids, or what our parents would say to us, which is, thank you very much. I'm your mother. I think I can make my own decisions for myself. And sure enough, she gave him a loan. And then she found out he was truly, madly, and deeply in love, not with her, but with her money. We don't know who he is. We don't know where he is. The money is gone. And a lot of people will say, for example, I would never do something this stupid. Why are you even worrying about something like this? Well, this happens more than you would like to think. And especially in a relationship, whether you're married or unmarried, opposite sex, same sex, usually in most relationships, one person is dealing with the money. That's the person who's dealing with the investments, paying the bills, etc. Unfortunately, that's almost always the person who dies first. Any of you watching this with your significant other might say, thank you, honey, that'll probably be you. But all fun and games aside, this is a very serious matter, because you're not only leaving somebody with the grief of your passing, you may be leaving him or her with a huge responsibility that he or she is going to be completely unprepared for. And you can still have it where you have your trust continue after your death. Somebody manages it, maybe gives your spouse all the income and invades the principal if necessary for him or her to sustain his or her lifestyle. At the same point, not giving them access to the principal, because the money can be gone very quickly. And for a lot of people, even though I state, a lot of times people do make good decisions, I don't know if anyone watching this program can say they never dated the wrong person, never fell in love with the wrong person, never married the wrong person. And honestly, over the last 2 years, I just read a few articles and have seen a few documentaries or movies, to say the least, where they said this is actually on the rise with COVID and with online dating, et cetera, which is becoming more the norm than less the norm. A lot of people are swindled out of a lot of money unwittingly, and sometimes you have to protect somebody from themselves. And this is where we get to, you can give income to a beneficiary without giving them control. What if you have minor children or young adult children? Well, if you have not properly planned ahead of time with a trust or something like that, the money would be held for them until they're 18. And when they're 18, they get unfeathered access. I've had a lot of people come to me and they are livid because their children are receiving money from their grandparents, perhaps a deceased parent, maybe a sibling, and they might be getting $50,000, they might be getting $1 million, whatever it may be when they're 18. And the parents are like, well, hey, I want to make sure our kid doesn't get all this money when they're 18. Well, should have been some planning ahead of time. There's nothing I can do. They're getting everything when there's 18. That's the way the law works. But ideally, at least when I'm planning for an adult, if you have minor children or young adult children, you might say, for example, if I die, this money will be held for the benefit of my child or children. Somebody can use that money to pay for their living expenses, their schooling, etc. And maybe they'll get a third when they're 25, a third when they're 30, a third when they're 35. Could be different ages, but that's usually pretty typical. Other things are, what if you want to give money to somebody, but that person is on Medicaid? or is likely to be on Medicaid? Well, if you give them money directly, it will knock them off Medicaid. I've had this happen, and I've gotten a number of frantic calls on this too, where somebody said, well, my mom just received all this money and he or she is going to be knocked off Medicaid. What can I do? Nothing you can do. If you've received money and you now have, at least in Illinois, in excess of $2,000 that hasn't been properly addressed, you have to spend down until you have $2,000 again. You'll be knocked off Medicaid. If you've got, if you've got public money being spent for your housing, you might have to leave that. You have to spend down to $2,000 again and then reapply for Medicaid. There's something called a special needs trust. It used to be you'd say, well, I've got 2 kids, one who's on Medicaid, one who isn't. The one who's not on Medicaid, will get everything, but you could do that, but that's leaving out the other child. The other way is to say I give half to the child who can make his or her own decisions and the other half to the child who's on Medicaid or whoever that beneficiary may be. There are some age restrictions. That'll go into a special needs trust, and it can be used to supplement the government needs. Also, what if you want to give money to a beneficiary who has some type of issue, drug or alcohol, or perhaps a gambling issue? You want to make sure that he or she has a place to live, but you want to make sure that he or she cannot sell that property or dip into money or principal. There are ways to handle that too. Now, people will ask me, well, what about estate taxes or death taxes? In the state of Illinois, if you're worth less than $4 million, at least this year, and as of today's date, you don't have to worry. And federal estate taxes don't come into $11 million adjusted for inflation. I think it's close to 12 and a half at the moment. Those could obviously change over time, but at the same point, you don't have to worry. If you're near that, if you're over 3 million, if you're near or over 4 million, then there's some estate tax planning we can talk about as well, but that's beyond the limits of today's program. That's something you really need to address in person. And some people will say, well, I did my will and trust, etc. I did it pretty recently. Well, if you did it before January 1st of 2020, it doesn't comply with the current trust code, assuming you do have a trust, even if it says everything you want. And it's a little questionable. Some clients will tell me, well, what happens if I don't do this? I don't have a great answer yet. There hasn't been a lot of case law to say what happens if you don't abide by it, what happens if you don't put in the extra provisions to comply with the current law. I don't know. I usually tell people, well, a good estate planning attorney will usually tell their clients, and every few years, I generally call my clients. I've been a little more restrictive during COVID and telling people, yes, you should come in during a pandemic to update. But most of my clients, as they've called me, or over the years, I eventually call all of them and tell them, yes, you should update your forms. You're doing estate planning, and one of the best things you can generally do is to hire an estate planning attorney to do your work for you. If you choose to do nothing, probate has been around for a long time, as well as guardianship, and it will continue to be around for a long time. If you have an attorney and he or she concentrates in estate planning and does his or her job, it should work fairly smoothly as long as you keep the attorney up to date with your current circumstances and you call him or her every few years as well. But if you don't abide by it, if you don't abide by the changes to the Power of Attorney Act, things may not go so smoothly. It might be a much bumpier ride than as opposed to if you made sure everything was updated. And that's the way I think it usually should go. It'll make it an easier transition for you. It'll make an easier transition to your spouse or significant other, and an easier transition to your friends, family, and or charities if you'd like to. So I usually tell my clients that it is a good idea to update these. There are a number of changes in the law, and the type of trust you have really dictates how important it may be. But I think for all trusts, they really should be updated to comply, especially when there's a major overhaul. Now, don't worry, estate planning does not change as frequently as it looks in this program, but over the last 10 or 11 years, there have been a lot of changes to it, as there have been a lot of changes in the legal landscape, and God knows with COVID and everything else, hasn't made it that much easier. Which brings us to one more thing known as the Secure Act. This came in December of 2019. So right around the beginning of 2020, and when COVID came, we got hit with a lot of changes in the law. It was a lot of fun. This affects retirement accounts, things like IRAs, 401ks, 403bs, etc. It used to say that, if I died, I could leave it to anyone and could it be expanded over his or her lifetime. Now, with certain exceptions, you can leave it to a spouse and it can go over his or her lifetime. But anyone else, as I said, with a few minor exceptions, they have a 10-year period in which to take that out. And that may affect the type of planning, even if your trust doesn't need to be changed or your estate planning. How you dedicate your beneficiaries may change because of this. And that's something that should be addressed as well in your estate plan. Just because you listed a beneficiary on it doesn't mean you shouldn't tell your attorney, or that's not something that should be considered. And I'll go through before I get to that, I'll give an example or two of some things to do and some things not to do with one example. So a number of years ago, I had a client. He came to me because his brother died. His brother didn't list any beneficiaries, didn't have a will, but he was the only beneficiary because the parents were deceased. The guy was never married, never had any kids, and my client was his only sibling. And when the estate was getting towards the tail end, it was nearly about ready to close. I asked him, well, I know you're not married yourself. I know you don't have any children, but I know you've had a long time significant other. Wouldn't you want to make sure that she gets your money? Wouldn't you want to do some estate planning to make sure that this process doesn't happen to her? Because you've seen how long probate is, you've seen how expensive it is. And keep in mind, this was before COVID, which has, I think, extended the process, or at least in Cook County it has. DuPage and Lake might be a little bit easier, as well as some other collar counties. But Cook County, there are a lot more cases, and it is overwhelming the court system for probate to a degree. So he said, yeah, I think that'd be a great idea, but every year my significant other and I, we're snowbirds, we're gonna go away for vacation. I guess if I don't do my estate planning in the next 2 weeks, I'll just have to live until I come back. Those were his exact words. I couldn't make this stuff up. But no, shame for anyone who thinks he died on that vacation. He didn't. I got a call from him a few months later, and I asked him, oh, are you back in town? Are you ready to close maybe your brother's estate, maybe do your own estate planning? There was a little pause on his end. And he said, well, I thought I called you. I guess I didn't. A few weeks back, I was having some serious stomach pains. I went to the doctor. They said I had a tumor the size of an orange in my stomach and I had it removed. By the way, could you do a will and trust and powers of attorney and the other paperwork and send it to me? I said, sure, not the way I generally like to do things, but we can do that. I sent him the paperwork. He sent it back to me, and he came back to the Chicagoland area. And I told him, I put your house in your trust. Did you listen to me? Did you put your other assets in the trust? And he said, sure, Jacob, I listened to you. Fortunately, a few months later, he died, and he didn't listen to me. He decided he would listen to his girlfriend. Because why would you want to listen to your estate planning attorney who does this for a living when your friends, family member, and what you read on the internet give you so much more valuable advice? His girlfriend said, well, I know if you list beneficiaries on your bank account, it won't go through probate. You should list me as your beneficiary. But in case something happens to me, you should also list my son and my 2 minor grandchildren. Well, they didn't really understood what that mean. They never told me about this. And when he died, the house went to the girlfriend, but that $200,000 bank account went $50,000 to my client, $50,000 to her son, and $50,000 to each of the 2 minor grandchildren who won't be able to touch it until they're 18. And then they'll get everything. Not what my client had planned, but you need to discuss this with your attorney, because listing beneficiaries and everything has some unforeseen consequences. And while it can be part of your estate planning, if it is your only estate planning, you should watch out. Those usually never go too smoothly. So I'm not saying that it has no issue, but oftentimes people will listen to their banker or financial advisor and they'll say, well, you can just leave a beneficiary. I also tell people, you have 2 kids, you have $200,000. You die, you list each of your 2 children as beneficiaries. If they outlive you, great. They'll each get $100,000. But let's assume they both have children. If one of them dies before you and you don't update anything, what's going to happen is usually $100,000 will go, if one of your children predeceases you, the $200,000 will go to that child and leave your grandchildren, the children of a deceased child, completely out of it. Most estate planning documents say that money will be held for the grandchildren of a deceased child until, let's say, they're 21 or 25. That's one issue. Another issue that comes with leaving beneficiaries, which I do need to address, is, well, what happens in the event that somebody dies and you've also listed beneficiaries in this fashion? You have 3 kids, you have $300,000. They each get $100,000 when you die. One child spends the $100,000, one keeps $50,000 and spends half, and one saves it. But your creditors don't go away just because you've died. They will start suing your kids or the beneficiaries that you've listed. The one who spent it doesn't have any money left, they can't get anything. The one who has $50,000, they'll take the $50,000. And the one who diligently saved his or her share, they'll take all of that money. As opposed to if it went through a will and went through probate or it went through a trust, the creditors get their $150,000 first, and all the beneficiaries get their $50,000. Even for people who say, well, I've never owed anything in my life, I've paid it off. Usually your last year or so of life will be the most expensive. There could be hospital bills, hospice, nursing homes, etc., things that you just did not anticipate. And sometimes if you're disabled and you haven't planned, oh well, there's not a lot you can do about it. But really plan and choose accordingly. Don't just try to plan on your own. For people who try to do estate planning on their own, I usually tell them that's the worst case scenario. It's a lot more expensive to try to undo some poor planning. I had to tell one of my clients who thought he'd save some brother-in-law some money from doing a will, that the will that you wrote, where the beneficiaries are your relatives or your family members, may not hold a lot of water, and as opposed to spending hundreds or thousands of dollars on a will, it might have cost you $750,000 because that's half the estate, and that might be going to your niece. Nothing I can do unless your niece agrees. Fortunately, she did agree, but I had to tell him in writing, if she disagreed with anything that was drawn up, we were going to lose. There was not anything we could do with the law and the poorly drafted will that he had his brother-in-law sign. So always keep that in mind. Oops, sorry, clicked a few too many slides. So now is the fun part of today's program. We only have a couple more slides before we can get into questions and answers. So learning from celebrities, you can learn what a lot of celebrities did to ensure that you don't make the same mistakes. Michael Jackson will be the first one. Whatever you think good or bad about him, at least he had a good lawyer. I remember when he died, it was on the news, and all the newscasters read this very solemnly because he was previously married, and in his will and trust and other estate planning documents, it said, I have intentionally not provided for my prior spouse, and she is to be treated as dying before me. That's not the exact verbiage, but something like it. And they read it very solemnly, like, how could this attorney have drafted it? And why was this, very morbid language in there? Well, I guarantee you every estate planning attorney who heard that said, yes, at least he had a good lawyer, because this is going to make it very difficult for her to contest it and say that, oh, he really meant to leave me something. An ex-spouse, perhaps a spouse you're estranged from, a child that's estranged from, if you didn't list them and they come back and they challenge it, you're probably going to have to pay them some money or some heir. Some people will say, well, I don't have any heirs here. You have an heir somewhere. It might be your third cousin twice removed that's in a different country you've never heard of. You might have 20 or 30 of them. You might have one, but there's somebody out there who needs to get noticed or to be written out or to have a trust to get rid of them. But there is a proper way to get rid of them. If you have kids, the old way used to be to say, well, I've given my son $1. I didn't forget to name him. I didn't give him nothing. I'm giving him $1. But if you have language like that in your document, it's very arcane. It doesn't really comply with the current laws. You should have it updated. Robin Williams, well, very well-known actor. He'd had some estate planning, but either he didn't listen to his lawyer or his estate planning attorney wasn't very good. I'm not quite sure. But he had a successor trustee. He did not list a successor trustee in his estate planning, and his children were to receive the money at 21. Well, Most people shouldn't have their children receive the money at 21. Not a great idea for most of us, let alone somebody with an estate the size of Robin Williams. He had a successor trustee, somebody who would take over in the event he died or become disabled, but that person died before he did. And so his estate still wound up going through the court system and going through probate because he didn't list somebody else. Whoops. I usually tell people you need at least one person on your documents, but you should have two or more. Now, some people will tell me, Jacob, the reason I never did my estate planning, I don't have a will or a trust, it maybe keeps me up at night, but I don't really have somebody that I trust to make my healthcare decisions or my financial decisions in the event of my death or disability for my healthcare or finances. That's not a good reason not to do your estate planning. There are professionals that can be paid that are third parties that you can tell them exactly what you want. And oftentimes I think they are better than friends or family because they have no emotion involved. Yes, you're going to have to pay them some money, but usually not unless you die, become disabled, or you just no longer want the hassle of making your own decisions. And usually people will balk. Well, they say, well, you know, they're going to take a third of the size of my estate, or not a third, sorry, maybe 3% of the size of my estate. That's a lot of money. And I tell my clients, have you ever seen an entire estate go to litigation, to attorney fees, et cetera? Because I've seen it. Better to plan and do what's best for you. One of the worst stories I ever heard, fortunately, this lady had a good banker, was from her banker. And she said, well, I don't have a lot of friends or family, but I have one good friend from church. You know, I've only known her for a year or so. I'll make her my power of attorney for property. Now, the banker went above and beyond what any banker I know would have done. He looked this person up. That person, who was this nice old lady's friend, had multiple felony convictions in several states for stealing money from the elderly. So choose and choose cautiously. That new best friend that you have may sometimes not be the best person. You know, somebody you've known for many, many years, maybe, but choose and choose accordingly. And while I tell people, most times people do choose a spouse or friends or family member, always consider a third party because that may be a better choice for you. Philip Seymour Hoffman. He gave a lot of money to a lot of good charitable organizations during his lifetime, but when he died, he had a simple will and he was not married to a significant other. If you are married, there are some tax benefits if you have a taxable estate. He did. But while he gave a lot of money to a lot of good charities when he was alive, because he had a simple will, because he wasn't married, and because he didn't do enough planning, the largest charitable beneficiary of his estate wound up being the IRS. Mickey Rooney. I'm a movie buff. I love old film. And Mickey, like a lot of Hollywood actors, was married more than once. But unlike today's actors who are only married 2, 3, 4 times, Mickey obviously could not get enough of a good thing because when he died, he was on his 8th marriage. And that was the one that really did him in. If you're on your 2nd, 3rd, 4th, 8th marriage, you might not want to make your spouse your trustee or power of attorney. What happened was his wife and her adult son managed to imprison him in his own house, steal all of his own money. But at some point he was able to escape. He had his day in court. The judge ruled that the money had to be returned to him, but he died without ever seeing any money back. Prince. Now, Prince was known in the music industry for being a brilliant guy. He fiercely negotiated his contracts. You were not going to get his music for free. You were going to pay for it. His music, his money, his videos, anything that he had. But even though he lived like a genius, he died like an idiot. He had no will whatsoever. His estate, I think, is almost settled now, maybe 4 or 5 years later. But up until recently, the only people that had received any money from his estate were accountants and attorneys. At least some of the money went to a good place. Jim Morrison, the lead singer from The Doors, decided he really didn't need somebody to help him do his estate planning. He'd do it himself. He downloaded something off the internet and did his own will, leaving everything outright to his wife. Unfortunately, she died about 6 months later. They had no children. And I usually tell people, if you don't have a plan in place, the state where you live has a plan in place for you. But because they had no kids, his wife's closest relative was her father, who was still living. Her mother no longer was. So within 6 months of Jim Morrison's death, his estate wound up going to his father-in-law. There was some litigation, and Jim Morrison's family did get some of it later on, but probably not the way he had anticipated his estate was going to go. A well-drafted estate plan really could have avoided the situation. Aretha Franklin, she was a very private person. I get calls from people like this all the time. They will call me and say, I'll ask them, when you come and meet with me, I need to know how much money you have. And they'll say, well, I don't really want to tell you. And I have to say, I'm sorry, there's not a lot I can really do for you. It's like going to the doctor, refusing to undress, refusing to tell them what's the matter with you, and asking them for help. It's not a reasonable request. It's leaving somebody in the dark. And she was a private person, just much like that. I guess her attorneys for years were trying to get her to do estate planning, a will, a trust, something. When she died, they thought there was no will, but she unfortunately had a few wills squirreled away somewhere in her house, one drafted in her own hand, one that might have been witnessed, going on for years, litigation, lots of problems. This is the perfect nightmare, doing something on your own, not listening to anyone, not trusting anyone, but then taking matters into your own hands. So really have a professional deal with it. Don't leave it to chance. Edgar Bergen, he was more famously known, he was a ventriloquist many years ago. Candace Bergen was his daughter, and she was more famously known for Murphy Brown. And this really illustrates that even if you have children or friends or family, you don't have to leave them things equally or leave anything to them. I always warn clients, and what happened in his case was he chose not to give his daughter anything, but he gave about $20,000 for the preservation of his ventriloquist dummy or puppet, for, lack of a better term of it. Now, while you can do this, and while Candace Bergen probably didn't need her father's money, I always caution my clients against doing this. Yes, maybe you have 2 or 3 kids, maybe 1 or 2 of them need it more than another. But if you want your kids never to speak to each other, this is the way to go, because it can really sour relationships between a family. I can do whatever somebody wants as long as it's legal. At the same point, I always caution people, really give some thought to this before you do it. Also, I've had a number of people who said, well, we gave money to one of our kids, maybe for, going to school, maybe as a down payment for a house. Don't leave it to chance when your child says, oh, I'll give my other sibling or siblings, that money. Of course, I won't take it from your estate. Everyone says that. I've been practicing for close to 18 years. I've never, ever seen somebody actually do it. They usually say, well, that was a gift. Their siblings won't speak to them, but that money that you loan to them, quote unquote, will never be returned to your estate. So usually in that case, it might say if you gave them, quote unquote, $100,000, all the other siblings get $100,000 first, or $100,000 adjusted for inflation. And then everything after that gets split equally between your kids. Really think about that. Britney Spears, she had multiple mental breakdowns. She didn't have powers of attorney in place for a long time. Her father was her guardian, wasn't her guardian, was displaced, guardianship was removed. Big headache, something big in the news, but this really illustrates, even if you're younger, you should be concerned with disability. And the last thing that you want is somebody that you don't really want in control of your money, your estate, your healthcare decisions, etc. So, and I'll go on with one more slide and a couple of notes before I open it up to answering some questions. So I realize I covered a lot of information. I hope it's not overwhelming. If you need to see this program again, it is recorded. It'll be available for about a month there afterwards. I think it'll be on the Schomburg's website for about a month or so after it is up. But really all you need to begin is you have to have an idea of what your assets are and their value. Just because your assets are in the stock market or it's changing day to day, most people have an idea if your house is worth, $200,000 or $2 million, whatever it may be. And the same thing for your other assets, as long as it's a decent ballpark figure. If you tell me your estate is really worth, $1 million and it's really worth 1.1 million, not a big concern. If you tell me it's really worth 500,000 and it's really worth 7 or 8 million, that's a problem. No attorney is going to be able to adequately plan for that if they're not given a good idea. Also, who are your beneficiaries? Who do you want to leave your assets to when you die? And then you should contact an estate planning attorney. Don't tell the attorney, I think I need a will and a trust. Let them know the assets that you have, the beneficiaries that you want to leave your money to in the event of your death, and allow the attorney to guide you and give you some potential examples of what you think you'll need. Also, there's one question that I'm going to address before I go into Q&A, and that's, what's this going to cost me? Well, I usually tell people, at least I will not quote people over the phone. I won't quote them over the internet. This is a library program. Even if I wanted to, I couldn't. I wouldn't be coming back. But I usually tell people the way I work is, you can meet with me for up to an hour. You can tell me what you have. You can tell me what you want to do. If you want to move forward, it's half up front and half once completed. But if you don't like me or you don't like my fee, you get a handshake and perhaps a letter that says I don't represent you, but that's about as best I can do. Because I really need enough time to evaluate somebody and see what their situation is. Sometimes I have estates that are few $1 million that are very simple and straightforward. And sometimes I have ones that are much smaller estates that are very complicated. Because I could have, for example, a $1 million estate and somebody says, I live in an apartment, everything goes to my one adult son. And if he dies before me, he has one adult daughter and it goes to her. That's a lot simpler than somebody saying, I've been married 3 times. I have children from each of the prior marriages. One of my children is disabled. I own a few businesses with a partner. I own a few pieces of property in state and out of state, et cetera. That's night and day for what a lawyer needs to do. So I won't comment on anything on pricing, but as I said, that's as fair as I can be. And most good attorneys will do the same thing. They'll say, meet with me. Up to an hour. I won't charge anyone. I can't state anyone else's on that if they charge for the consult, but that gives you the chance to get to know me, for me to get to know you, and to get to know what the situation really is and what needs to be done and what your options are. So without further ado, I will start taking some questions.
Hi, Jacob. I'm going to allow you a chance just to take a sip of water and catch your breath for a moment.
Sure. Thank you.
We have anywhere between 7 and 9 questions and comments. So would you like to take them one by one, or would you like me to read them off to you?
Let me take them one by one. I'll look through them. First, I'll go through the chat, and then I'll go through the Q&A.
Okay.
So want to trust, and keep in mind also before I answer any of these questions, this is for informational and educational purposes only. Somebody asks me something that's legal advice, I'm going to politely decline and say, I can't answer that. You need to get legal advice from, an attorney in his or her office. So when a trust is set up to provide income without access to principal, who usually administers this, and are there usually management fees associated? And if so, what is typical and reasonable? Well, fees I will not discuss. Who can be the person? Answer is it depends. If you, for example, let's say you have a family that gets along well, and let's say married couple, husband, wife, and adult child. Adult child is good with money, has a good relationship with their parents. And, one of the spouses really doesn't want to handle the money or just isn't good with money. They might say, okay, well, we'll allow our child to be in control of it if I die, because this will be overwhelming for my spouse. You could have that, or you could have a friend, a family member, or sometimes a trust company do that. You have, as far as management fees, there aren't necessarily attorney fees. Most attorneys will not act as the trustee. I will not act as a trustee. A lot of older attorneys used to do this, but these days, the only time estate planning attorneys are usually sued or the time where they're most likely sued, I should say, is when they're acting as the trustee and they've taken some money or mismanaged it. Our malpractice insurance goes through the roof. So I usually recommend, I can give you a CPA, I can give you a trust company, etc. But what the management fees are, I'm out of that. You have to ask them what the management fees are. I do not do that specifically. But that's what you generally can do. But I usually recommend at least considering a third party, no matter what the fees are, because I usually tell people, and there are a lot of stickier situations where, let's say there's a husband and wife, but there's a second marriage and there are children from the first marriage. If you give it to the spouse might take the money and give it to his or her own kids or his or her own family. And Vice versa, if you give it to your own kids, your spouse might be left out. So you might want a third party who's not in the middle of that situation. Oh, that was the last question there, sorry.
I'll scroll up. The next one is, if I have a will trust prepared in Illinois and moved to another state, is it still valid?
Sorry, I'm on a different one. Let me just read through them if you don't mind, please. Because I think I'm somewhere else. I'm sorry, I went down somewhere. Do I need a notary witness for a will? What about a power of attorney for a power of attorney? Well, different question. So notary for a will, it depends. In Illinois, you don't need a notary, but if you move to a different state, you might. For a power of attorney for healthcare, you need a witness or witnesses. For a power of attorney for property, you may need one or two witnesses and a notary, but I'm not going to give legal requirements on what you need to do for the forms. You have to look that one up for yourself for the actual requirements. Future program, 5 wishes, advanced healthcare directive. Oh, this is from
that's
you.
just additional information. The next one is about the dollar breakpoint.
Okay. I cannot copy and paste info in the chat window. Will this be provided in another?
I addressed that.
Okay, sorry.
That's administrative.
Is there a dollar breakpoint where trust more desirable than a will? Well, I mean, a will may be okay. I'm not going to say it's better or worse. I don't know, obviously, everyone's situation. You know, if you have less than $100,000 in total, meaning your house, your IRA, your 401k, your life insurance, etc., a will might be sufficient. If you have any real estate in excess of $100,000, including all of your assets, even though you might have named beneficiaries, usually a trust might be better. But as I stated before, it's a case-by-case basis. I can't really comment on somebody's exact circumstances without really getting to know that. You know, you might only have a $80,000 estate, but if you're leaving it to your minor child who's 5 years old, you might want a trust or a will that has something called a testamentary trust in it. Jim Morrison died in 1971. Okay, maybe it was an internet will. Maybe it was a, you know, something you got from a stationery store, but also besides the fact. So if I have a will trust move in Illinois and move to another state, is it still valid? Well, chances are it's still valid, but I always tell my clients to have an attorney there, look it over to make sure it complies, because the rules for different states may affect it differently. Every state has its own power of attorney laws, and they're supposed to apply their own laws to your forms, but that may not work. Same thing with wills and trust. It just depends. But just because you're maybe moving to another state in a few years. I've had clients who have been moving to Florida for the last decade, but they're still in Illinois. So you should at least do some planning and don't avoid it because you may move, you know, or just obviously don't die or become disabled before you do move. Let's see, what happens to assets not in a trust or a will accrued after the last update? Well, I mean, I'm not quite sure of the answer. You know, if you have assets in an old will or a trust, that may still go through it. It's just if somebody challenges it. There are a lot of things dealing with accountings, who is required to receive notice in the event of your death or disability, et cetera, and then trying to comply with it. I don't really understand the question that well. So if you want to rephrase that, I can try to address it again. Okay, and then let me go to Q&A because I think chat is done. Is a trust needed for a small estate? Well, it depends what a small estate is. Needed, you don't necessarily need a trust for a $50 million estate. Would it be a good idea? Yes. Now, small estate, one under $100,000, it may or may not be needed, but as I addressed before, some estates It really depends. Who are your beneficiaries? Is that somebody who is disabled? Is that a minor? Is it somebody on Medicaid, somebody with a substance abuse problem? There are some wills that do contain testamentary trust, which mean basically it still goes through probate, but it can be held after your death. But those are generally used when you have minor children for smaller estates. Usually larger estates, but as I said, it depends. I have one client now who had a $5 million estate. He would not do a trust. So now we're stuck in probate and it's taking forever. But that's a different story, but I've had some estates, sometimes even a small estate. You should have some planning, but as I said before, what's appropriate for you, I don't know without knowing you and your situation and your assets. So if we already have an estate plan, do we need a simple will? Well, I don't know what your estate plan is. Your estate plan could be a power of attorney for healthcare. Most of my estate plans are at least a power of attorney for healthcare and property at an absolute minimum for somebody who has absolutely no money is 18 or older. Usually they include a will or a will and a trust. Now, a simple will, as I stated before, if you have a trust, you might need a pour-over will. You can always have a will without having a trust. But if you have a trust and no will, that is a problem because trying to get every asset that you have in a trust is difficult. And as I pointed out earlier, a will is meant to deal not only with the assets that you have now, but assets that you may have in the future. Maybe somebody leaves you some assets. Maybe there's an asset you forgot about. Maybe you die because of a personal injury or wrongful death case. There are a lot of what ifs. Okay, so do I recommend setting up a toady for my home? This will keep the home out. Will this keep the home outside of probate? I just refinanced the home for 20 years in the amount of $150,000. Well, a toady is known as a transfer on death instrument. It's been in Illinois for maybe a little over 10 years or so. And transfer on death instrument is sort of like putting a beneficiary on real estate. I do not like them. Almost every estate planning attorney hates them. And I will tell you why. First of all, that's like leaving a beneficiary. As I pointed out before, you listed your 2 kids on a toady, one dies before you, everything goes to the survivor, potentially leaving the children of your deceased child out of it. B, if there's litigation, not a lot of case law. Trusts have been around for hundreds of years, toadies in Illinois for about a decade. Thirdly, and this is a nasty one that people don't realize, if you do a deed, let's say you do, Illinois does have something called a land trust. It's only for real estate, but still it's not my preferred method. Usually I like a living trust because a living trust can do a number of things. It can own real estate that is in Illinois or outside of Illinois. So I've got some clients who live here who don't own real estate here, but own real estate out of state, or they own real estate here and out of state. And if you own real estate in Illinois and out of state, and you have it's not in a trust or isn't in some type of proper vehicle, you're actually going to have probate in that state. And you're going to have probate in Illinois, which is difficult, time consuming, and expensive. A living revocable trust can deal with probate in and out of the state. A land trust only in Illinois, but you can have beneficiaries and it can also plan for people, if you had minor children, what might happen to them. If it's only for real estate, still, I think a living trust is better. But the nasty, nasty, nasty thing about toadies is, when do you die? Used to be a little easier to record deeds a little bit more quickly. Most attorneys nowadays, because of COVID, we send our deeds or toadies, if you do one, to your title company, and it might take a few weeks. It used to take a few months to get them recorded. It just depends. But let's say, for example, I have a client that signs a deed. They put their deed in trust. They're putting their house in a land trust or more than likely a living trust. They sign it with me today. The deed is not yet recorded. Maybe it's in the mail to the title company. Maybe it's getting recorded, but it's not recorded yet. Well, they die over, let's say I'm doing this on Monday. They die on Friday. It's not recorded till next week. If you have signed that deed, even though it's not recorded, it's still in the name of the trust. A toady, it's not the same. If you signed it today and it's not recorded and you die before it's recorded, the toady is completely ineffectual. It has no legal bearing whatsoever. So I'm not a huge fan of it. I think it was done by the state, unfortunately, for people who maybe didn't have a lot of means or were trying to plan on their own, but I think it was a poorly thought out statute. Could it work for somebody in a limited circumstance? Yes, but I don't like them. And most of the attorneys I've spoken with also are not fans of toadies. So let's see. If I have, okay. Let's see, can we include overseas assets in a will or trust? If so, what kind of documentation do you need for foreign assets? Can I appoint one of my children as clerk or another capacity in the trust secretary and pay salary? I'm not quite sure what they mean to the second one, but let me see. So if you have assets overseas, it is a nightmare if you want to include them in a will or trust that's drawn up in the state of Illinois. One of my colleagues who used to be the head person at one very large firm and dealt with this said, you never want to do that. It will be a headache. You want to expressly exclude any assets that you have overseas and do a will or trust or corporation or whatever legal documentation is required in that state. But you have to tell your attorney here, because I will usually state, if you have assets in France, I'm expressly excluding any assets that I have in France, and that'll be dealt with a separate instrument, in that county. Then otherwise you get into international will and trust laws, treaties with other countries. It's extremely difficult. And most attorneys are not going to want to take that on. You're going to be talking somebody in a very large firm charging a very large fee that could have really been avoided. Can I appoint my child as the clerk or as a trust secretary and pay salary? I think what they mean is, okay, so if you have a will and you name them as executor, the person who's going to manage the estate, or the successor trustee, who's the person who's going to manage the trust in the event of your death or disability, usually they are entitled to receive money. Oftentimes they don't. Now, if they take a fee for it, that is going to be taxable income to them. So you do have to realize that. That's the first thing. Most laymen, meaning somebody who's not an attorney, a CPA, they can probably charge about 25, 30 bucks an hour. An attorney or a CPA or maybe a financial advisor could charge more for his or her own expertise. I usually tell my executors or trustees, even if you're not going to take a fee, you might want to list, the date, what you did, how long it took you, etc. You may not take a fee. Most people generally don't unless they're not getting any money from the estate or it's very complicated or a big headache, but they can get a fee. I don't usually suggest them getting a flat fee, because if you say $50,000, well, great. What if they did 2 hours of work? That may not really be worth it for them. Of course, what if they did 2,000 hours of work? Then 50,000 might not be enough. So it usually states that they can get a reasonable fee. How does a will and a trust work together? Well, let's assume that you have 20,000 in a bank account when you die, and the rest of your assets are in a trust. When you die, there will be some paperwork filed. That $20,000 will usually have a form plus a certified copy of your will. That money will then go to your trust, and your trust will distribute the money. It's making sure that in the event of your death, you don't have some money going through your will and being paid to the terms of your will and some money going through your trust. All of the money is going into one pot, which is your trust, and your trust is paying the money out. What is my fee to review an existing will and trust to get another opinion? So I will look at somebody's, usually if it's older or if I think it's terrible, I will say I will redraft it. Keep in mind, even if clients say, oh, I just want a small change, most estate planning attorneys are going to say, I'm going to have to redo it. No attorney in their right mind wants to rubber stamp it and say it's good. It's good because that means we take liability for somebody else's work. So I will not actually, I can look at it, but I'm not going to ever write you something or charge a fee to say this is good or bad. I'll tell them, I think this is problematic. I think this is old. If you want to make changes, I can redo all of it. But as far as changing a fee, almost every estate planning attorney out there, maybe not some general practitioners, maybe not some very young or very old attorneys will do that, but I would usually redo it. I don't want that liability. That's too much for any fee. So yeah. Let's see, if I have a will and a revocable trust, is that what is called a pour-over will? Without seeing your document, I don't know. It probably is, but it may or may not be. Some people will actually draft a simple will and a living revocable trust. Usually that's not a good way to go, but I don't know what you or your attorney did. Is a power of attorney for property for when you are alive and your executor is for when you have died? Yes, so power of attorney for property is when you're still living. When you die, the power of attorney for property ceases to exist. The power of attorney for property may come into effect now if you sign it that way, or it may only be when there's a triggering effect in the event of your disability. A will only takes place in the event of your death, but a trust does. It's a hodgepodge of both. It works like a better version of a power of attorney for property while you're alive and you're disabled, and it works like a will that avoids probate when you die, assuming you have properly transferred your assets into it. Would it be better to safeguard? Would it be a better safeguard to add your beneficiary's name to the title of real estate? Is listing a person as the beneficiary of IRA sufficient? Again, cannot give you legal advice. You can name beneficiaries. It may or may not be sufficient. I don't know your situation or your beneficiaries. But I will point out a very nasty, nasty thing if you add somebody else's name to a deed. If you are giving them an interest, let's say your house is worth $200,000, you now put your son's name on the deed as a joint beneficiary because this will avoid probate. You have unknowingly done something that most people who are not estate planning attorneys don't realize. There is one potentially good thing, but there are a lot of bad things. So you have now given them a gift of $100,000. You are legally required to file a gift tax return with the federal government to show that you have given them in excess of the amount that you can give in a single year. This year is either, I'd have to double check, $15,000 or $16,000. Also, if your son is then sued in that scenario and he or she doesn't have enough insurance or assets of his or her own, they can foreclose and take your house. See, another nasty little thing, we have something in tax terms called a step up in basis, and let me explain what this means. If you die, and let's say you bought a stock for $20, and you sell it during your lifetime for $220, you're going to pay tax on that $200 of appreciation. But if you keep that stock until you die and it goes to your kids and they sell it at $220, at least this is the way the law currently is, they don't pay taxes on that $200 of appreciation. But you've now given them half of it. So when you die, they get a step up in basis for the $100 of appreciation, or your house, which could be $100,000, $250,000, whatever your house is, half of your house is worth. But the half that you've given to them when they sell, they're going to have to pay taxes on that, which is probably going to cost you or cost them more in taxes than they would have saved on going through a probate estate. The only good thing about it is if you, and I'm not a Medicaid expert, I cannot comment to make sure this is 100% adequate. If you did this 5 years prior to applying for Medicaid, at least for half of the home, that may exclude it from Medicaid taking that interest in the home in the event of your death. But for most people, I think the shortcomings for that usually exceed the benefits. So I don't, if people tell me that's what they want to do, that's fine. I just write them a letter that said, we went over these. Don't blame me if this is a problem later on. So let's see, can you repeat what you said about meeting with you for 1 hour, less fee, and was it half up front to prepare the document? So meeting with me, generally I state that, you call me on the phone, please don't email me. It's difficult to get a day and time in place. But what we need to do is usually people call me, we can schedule a day and time to meet. You tell me exactly what your assets are. If you're married, what assets are yours? What assets are your spouses or significant others? What assets you own jointly? I might need some more documentation depending. I will meet with you up to an hour, and at the end of it, I'll state based on what you have and what you want to do. This is my price. These are what I recommend. I might have one or more plans for you. And if you want to move forward, I'm going to need a check up front before I do any planning for half of that fee and the other half of that fee plus any filing fees when it's complete. That's as fair as I can be to anyone. Now, somebody else saying, my father passed away about 20 years in Ohio. My parents had a trust and almost everything went smoothly. My father had a small estate investment, not a listed, about $2,000. The fees ended up costing more than the investment was worth. What would happen in Illinois nowadays? Well, I can't really comment on what happened in Illinois, what the fees would be. I don't know the scenario. Sometimes if it's a very small amount or they know about what that's worth, I tell people not to go through with it. Illinois does have something, assuming that you know all bills have been paid, assuming that there's maybe only one account, we can do something called a small estate affidavit, but what needs to be done for that, I don't know. Sometimes people have more than one account. Sometimes there's still some creditors. Sometimes I have to file a will, get it notarized, etc. So I usually, if somebody can tell me what's in the account, sometimes your financial institution won't tell you. I can tell you what it is, but I can't give an exact fee because I don't know what I'm dealing with. I've had some, some of them cost a few hundred, and I've had some of them cost over $1,000. It's kind of a case-by-case scenario. So that's really all I can state. Let's see. And did any other questions come in, Patty?
No, I think you are, you encompassed all of them, and we are nearing up to about 2 hours. So
okay.
I think our last question was addressed. And again, I want to thank everyone for making time to come out and join us for this session. Jacob, and a special thank you to you. I will be notifying everyone tomorrow by email of the link once this is up and running on our Schomburg Library YouTube channel so that you can have it, you can review it, and you can also share it with others that may not have been able to join us. But Jacob, thank you so much for all of your content, your presentation, and for bringing this topic to us.
Okay, thank you, Patty. I hope for all the patrons, I hope you enjoyed the program. And as I said, if you didn't get enough of it or somebody missed it, as Patty stated, you can see it again recorded for the next month or so.
All right, take care, everyone. Stay healthy.
Thank you. Bye.